Well, good morning, everyone. Thanks for joining us today. I'm Wes Lang with KO Law, and we're really glad to be hosting today's webinar. We're going to give just a few moments here as people continue to get logged on before we get started. Should we get the presentation dialed up, Charu?
Are you able to see the slides?
Not right now.
Oh,
I could see it, guys. It might have been the button at the top, where you can click over to see the screen share.
let me try this again.
There we go. We're rocking. All right, well, as folks are dialing in, I think there's just a few housekeeping items and logistics that we wanted to touch on. First of all, we are recording this, and then we will distribute it after the webinar ends as well. So you both have a copy, and for those that aren't able to maybe attend for the whole session, you'll have a full recording. Also, for any attorneys out there that decided to join us today, CLE credit is pending, and we'll follow up with the course ID if it's approved for the live webinar, along with information for home study credit related to the recording. We do have a packed agenda planned for this webinar, but we're aiming to reserve a few minutes at the end to answer any questions you all may have. If you see on your screen, there is a Q&A button at the bottom of the screen. So if at any time during the presentation something comes up that you want to ask, feel free to send the question our way. We'll be able to address those at the end. And then lastly, while we're going to try to address all questions, depending on timing, if we can't answer your individual question, or maybe you have a more nuanced question that you want to address specifically, we will be sharing our contact information at the end, and we'd be happy to address those or other follow-ups you may have. And then lastly, it's our obligatory call out, but today's presentation, we will just be discussing general best practices, not giving specific legal advice. So we do recommend working with an advisor directly to handle any of your company's specific circumstances. So let's get started. For those of you who weren't on yet, my name is Wes Lang, and I'm a member of our Operational, Commercial, and Technology Contracts practice group here at KO Law, which is really just a long-winded way of saying that I support clients' day-to-day business and operational contracts, predominantly in the technology, consumer products, and food and beverage space. And then my esteemed colleague here, Charu Ganesh, she is going to be kind of the heavy hitter here as we dive into the substance, but I'm going to give her a moment to introduce herself and let you all know who she is.
Yeah, thanks, Wes. I am Charu Ganesh. I am also part of the commercial team at KO, and I do a lot of similar things to what Wes just described. I do represent a lot of clients that are in the tech and software space and have been in a lot of negotiations with large financial institutions over the last year or two, and have noticed some really interesting patterns, trends, and that's kind of the impetus for this. But before I kind of get into those specifics, I'll let Wes kind of give you an overview of KO, what we do, and we can go from there.
Yeah, thank you. I'm sure many of you are familiar with us. If you're current clients, thank you for joining us. But just kind of to give you a little bit of background on us here at KO Law, we really pride ourselves on being companies' go-to business attorneys. We're based in Colorado. I'm coming from our Denver office. Charu's up in our Boulder office. But while we're predominantly based in Colorado, we do have a presence in North Carolina, but we do support clients nationally and some internationally as well at every stage of their life cycle, from startups to Fortune 100 companies. We do everything from helping companies form, get financed, grow, and exit, while also providing outside general counsel support for businesses of all sizes and stages. As you'll see here, we kind of operate in three predominant core practice areas. Our corporate and transactional law group, think of M&A, financings, and corporate governance work. Our commercial transactions team, which Charu and I are part of, that work closely with clients on their day-to-day revenue-driving contracts and other commercial transactions. And then our data privacy team that helps clients get on top of and be proactive with the ever-changing global data privacy landscape. With that in mind about who we are, let's kind of talk a little bit more about what we're talking about today and why you're here. So kind of four main areas that we want to cover today. First is an overview of operational resilience and the impending effectiveness of this new regulation coming to effect in January in the EU DORA, along with maybe touching on some other kind of regulatory regimes in this space globally. Second is what types of vendors DORA applies to and why this EU-based regulation matters here in the US. Third is how DORA and other regulations are going to affect tech vendors working with financial institutions, again, predominantly in the EU, but who knows where these regulations may lead in the future in the US. And lastly, kind of some best practices and recommended steps that companies can take proactively to set yourselves apart in today's competitive marketplace. So I think with that, Charu, why don't we dive in? I think the best place to start is to give us a little bit of background and context for what the regulatory framework is now, what it's stemming from. And I think that the critical piece here is what is operational resilience?
Yeah, so operational resilience has become a bit of a buzzword in the financial services sector in recent years. This essentially means the ability to maintain operations during disruptions. So not necessarily immunity from hazards, but rather the ability to prepare for, adapt to, withstand, and recover from these disruptions while still continuing to function. So this is all kind of a product of the increasing digital risk in recent years. So, I mean, we've seen AI used for malicious purposes, an increased volume of attacks, and cyber criminals often do target service providers rather than their actual intended victims themselves, so like the financial institutions. So this is something that regulators have really been grappling with around the world. And the idea is not to, like I said, prevent hazards, but to ensure that while there may be natural disasters, tech glitches, anything like this, the financial services system is still stable and the markets are not affected by those things. So I'm not going to go into too much detail about the specific global regimes, but all you should kind of be aware of is that there are operational resilience guidelines, regulations, laws, frameworks, policies, all of that across the world. They vary in their level of complexity. And we're going to spend most of this webinar talking about the EU, but there are some things that kind of intertwine this concept into US policy and regulations as well. So
it's interesting. I feel like we've seen this before, kind of looking back in the looking glass. We saw that with privacy and GDPR, and then, excuse me, how these kind of regulations that go into effect may be predominant in the EU, and how the US kind of piggybacks off of or kind of leverages them to kind of create either on a state basis or federally our own kind of regulatory landscape. So interesting to think about kind of where we are now, and then as we kind of look towards talking about DORA, where we may be going.
Yeah, so I mean, it is interesting. So as you kind of take a look at the various, as you kind of take a look at where all of these regimes are located, and this is only kind of a small subset of this, these regulations have been kind of a bit of a patchwork for a while. So EU's DORA regulation, again, that we're going to get into in a moment, is meant to tie all of that together rather than create something new. So there are these established patterns, practices in other jurisdictions. But in the US, this primarily the concept of operational resiliency has come up so far in the form of advisories and interagency cooperation rather than actual rules and regulations. So the acting comptroller of the currency actually made a statement to bankers earlier this year indicating that our federal agencies do have the intent to establish baseline requirements for large banks, including third-party risk management expectations. So they did cite these other operational resilience regimes when they were making these comments. So it does appear that we're going to be following in their footsteps pretty closely. So let me take a second to actually talk about DORA. This is the Digital Operational Resilience Act. It's an EU regulation that's aimed at strengthening the financial sector's digital resilience. So the compliance deadline for financial institutions is January 17th, 2025. So that is less than 2 months from now. It is very close, and financial institutions have been working towards this deadline for over a year now and are looking to support from their IT vendors. There are a lot of obligations that they have kind of been grappling with in the background, but specifically, there is a lot of emphasis here on how financial entities are interacting with their vendors. So just to kind of give you a sense of the scope, this applies to financial services firms that are operating in the EU. So not necessarily like headquartered in the EU, but that have any sort of operations there. So a lot of US entities are also going to be covered by this as well. So this has a similar structure to GDPR and privacy regulations where there is a directly regulated entity and obligations are flowed down by contract to service providers. But I mean, let's start first with the directly regulated entities. Those would be financial institutions, and this is defined pretty broadly. It's not just banks. These are, insurance companies, financial consultancies, anything like that. I do want to acknowledge, though, there is another group of entities that is directly regulated, and these are called critical ICT providers. These are certain service providers that are designated by the supervisory authorities as, being critical to the financial system based on systemic impact, importance, and level of substitutability. So I'm not going to go into all of this in detail today because, frankly, it does not apply to most of you. I would be shocked if it applied to any of you, actually, because we're talking about service providers that have a huge portion of the market share that are providing services to the majority of financial institutions in the EU. And there is this really complex analysis that goes into that. So those vendors like AWS, Oracle, Google, they are going to be subject to direct regulations from EU regulators as well as the financial entities. But for today's purposes, we're just going to be talking about the financial institutions themselves and the entities that are indirectly regulated by virtue of providing services to them. So something you're going to see a lot in the regulations and hear me say today are the term ICT third-party service providers. And it's a bit of a mouthful, but it basically means any undertaking providing digital and data services through ICT systems. So there are 2 tiers of ICT service providers that we're going to be discussing today. And if you are a vendor that is providing services to financial institutions that are covered by this, you're going to fall within one of these two categories. So the first tier of these service providers, the ones that are going to be subject to heavier requirements by contract, are vendors whose services support critical or important functions of the financial entity. And then the other kind of group is the vendors whose services don't support critical or important functions. I know that I just mentioned the concept of critical ICT providers. There are two separate concepts of criticality here. So when I'm talking about supporting critical or important functions, I'm talking about service providers that are indirectly regulated that support these functions of the bank. I'm not talking about any of the direct regulations here. So I know that's kind of it's confusing having two separate mentions of the term critical here, but just kind of keep in mind that when I say that, I am talking about the indirect regulations there.
It's always fun when they could have used, a different but similar word to express it. So appreciate that kind of background on the who, but maybe we can dive into a little bit of the what. What is it really trying to get at? What is it trying to regulate in the sphere of operational resilience? And what is this kind of shaping up into for these financial institutions and then these, critical service providers?
Yeah, so there are what we call 5 pillars to DORA. So this regulation has a number of different sections to it, basically, and each of them deals with one of these pillars. We're going to spend today talking about the 4th pillar, which is management of third-party risk, because that is the only thing that is going to affect the service providers, really. The rest of these things are concerns specifically for the financial institution. So if we are talking about third-party risk management, there are a lot of elements to this. Again, everything on this page is really relevant to the financial institutions themselves. They need to conduct these risk assessments. They need to collect a register of all of their contracts with vendors and make sure that that information is available to regulators when requested. They need to regularly report things to their supervisory authorities. There are all these obligations, but the things that really apply directly to the service providers are going to be the contractual aspects of this. So there are these pre-contract requirements under the regulation, and then there are actual contract requirements. So I want to spend a second kind of digging into the pre-contract diligence process first. So the thing that the financial institution has to do before anything else when doing their risk assessment is determine whether the vendor provides critical or important functions. So there's that term again. I want to talk for a second about what that actually means. So this is a determination that's left up to the financial entities. There are a series of standards, basically, that they're looking at in order to categorize service providers. So the language used by the regulation is disruption could significantly impact a financial institution's financial performance, continuity of its services and operations, or that a disruption or malfunction would affect their ability to comply with their regulatory obligations. So those are the standards provided by statute. It's a little bit vague. There are suggested considerations from the Financial Stability Board. This is non-binding guidance, but it is an NGO that does kind of provide some insight into what we can expect from regulators. So financial entities are going to look at the financial, operational, or strategic importance of the services, what lines of businesses rely on those services, the nature of the data and information that's being shared, whether a disruption would impact the confidentiality or integrity of that data, and whether there are reasonable substitutes for that service provider's services that they're supporting. So most financial entities are going to err on the side of classifying all of their vendors as supporting critical or important functions, because that is going to be a lot easier for them. They will just have one set of contracts that applies to everybody, bases are covered. That is going to be their default position for the most part. So the onus is really going to be on the vendor to object to heightened standards if they believe they don't apply. So let me kind of jump back to this and explain how this weaves into all these concepts and why you should care. The pre-contract diligence process, it is really guided by what classification the vendor has. So in the due diligence process, for example, rather than just having to assess the security standards employed by that vendor when doing the diligence, the actual standard under the regulation is that they need to assess whether the vendor uses the most up-to-date and highest quality information security standards. I mean, as a contract lawyer, I would never agree to something that aggressive in like any sort of warranties or anything like that, but that really is what the financial institution is looking for here. So if you can kind of avoid that classification of supporting critical or important functions, the standard becomes a bit lower, and it is a lot less onerous for you. So these are all kind of the background things that the bank is doing pre-contract. There are also a lot of specific requirements for these heightened standards in the regulations as well under Articles 28 and 30. So we can kind of dig into that a little bit. And I'm not going to spend too much time on this, but if you are kind of curious about the types of functions that might be classified as critical or important and what that analysis looks like, we do have a sample mapping exercise here. We're going to talk in a moment about how to kind of do that on your own, how it might benefit you to get ahead of this and do this analysis yourself. But first, let's kind of talk about the differences and what actually needs to be included in these contracts.
I mean, it's fascinating, Char, because it sounds like, to your point, these financial institutions are incentivized in some respect to make everything as stringent as possible for every vendor, because it gives them the backstop that they are complying with regulations, since they're the ones who are directly regulated. And so it's an interesting risk shifting in some respect to have the vendor being the ones that are kind of pushing back to some respect in order to be like, hey, we actually aren't a critical function. We obviously are an important function, but then like balancing that negotiation process with wanting to be one of the vendors that this financial institution wants to use. And so it is an interesting line and dance to balance with kind of this early stages of the regulation and these financial institutions wanting to make sure they're in compliance with the reality that there are some flow down risks that vendors may have to deal with and may just have to deal with in order to get the business. That first piece is kind of that contract diligence and maybe a little bit more strenuous kind of peek into how your operations are. And then the other piece, is what is going into these contracts? What are these required contracts clauses? And I believe there's some that are required for all contracts. And then back to the critical function piece is some are only required if you are a critical function. And so it's the same as the contract diligence is, let's make that determination and talk about kind of where those lines are drawn.
Yeah, and I mean, it is really going to be up to the vendor whether or not they want to dispute a determination made by the financial entity that they support a critical or important function. But I think once I kind of get into the specific contract requirements, you might see why that would be in your interest. So I want to first start with the basic requirements for all vendor contracts. And for the most part, these are things that should already be in your customer agreements. So things like a clear description of functions and services, whether subcontracting is permitted, the requirement to cooperate with authorities and investigations, things like that we see in contracts all the time. DORA is more prescriptive than most regulations, though, and it does have a few kind of unusual requirements here. So one of the ones that is actually kind of being debated, and there are different interpretations of this, it requires you to state the locations where services are provided. It is a little bit, I mean, it's impractical to list every single location where an employee of a vendor is logging into the intranet to provide back-end services. So that's a really broad interpretation of what that requires. It's possible that they also, or that they alternatively just mean locations where the vendor has offices and operations. That might be something else, but this is something that the lawyers will be kind of going back and forth about when they're entering into these agreements and making sure these check boxes are taken care of. Some of the other weird ones that are required for all contracts, in the termination section, you have to include a termination right for significant breaches of contract and breaches of law. That is to be expected. However, the bank also needs to have the right to terminate for circumstances identified during their own third-party risk monitoring that could potentially alter the performance of the functions provided through the contractual arrangement. So it's not quite a right to terminate for convenience, but it gives financial entities considerable discretion in determining whether a vendor's performance is going to be altered to a degree that warrants termination. So that's something that is a little bit vague. Those are things that we might not typically agree to in a contract, but they are expressly required under this regulation. And then the other kind of weird thing that is required here is the obligation to participate in a financial entity's security awareness and training programs. So if you are representing a lot, or if you're providing services for a lot of customers in this space, it is obviously not practical to take part in every single one of their trainings. So it's a bit unclear what this actually requires. Regulators have stated that this will be satisfied by doing one kind of combined training if a single vendor is providing services for like hundreds of financial institutions. So this would be, something that is a little bit more universal, like a cloud hosting provider, something like that. If they have a lot of customers that have this requirement, there are ways to kind of consolidate that. For the most part, though, this is something that needs to be included there. It does not need to be for free. So vendors can always, they can always push back and say, oh, we'll participate in this, but for our standard professional services rates. Otherwise, you just have to take a look at what our own training procedures are and sign off on it, and then that'll be it. So that's one of the things that can be negotiated a bit, but it is an unusual obligation here.
That's the beauty and the curse of a new regulation is let's see how it pans out. You have some discretion, you have some ability to kind of move the needle one way or the other. And then there will also I'm sure there will be more guidance that will come out over time, kind of fleshing out, this is what we meant by this, what we meant by the other thing. And it does give these vendors some ability to have these conversations with the financial institutions and make sure that it's, hey, how can we help you address what you need to address, but also understanding what's the practical reality with maybe how their processes work and what is actually reasonable.
Yeah. Yeah, and I mean, this is like, there's always going to be room to negotiate because while there are really specific requirements, there aren't exactly like phrases and specific wording that needs to be included. So, I mean, it's always possible to say, well, that the way we interpret this is XYZ and push back on that. Obviously adds more friction to the process. Banks are going to want to just use the exact language to make sure that their boxes are checked. But I mean, everything that we've been discussing is only for that general, those are the general requirements for vendors in the sector. It doesn't even kind of get to the heightened requirements that are required for.
Yeah, that's just the tip of the iceberg.
Yep.
That's what every kind of third-party vendor has to deal with. And now kind of back to the critical or important function aspect, I think that's kind of where we're going next,
Yeah.
is hitting on that.
So that's also, I mean, like I said, you're going to want to decide whether it is worth it to push back on that kind of designation or not. But if you are classified that way, in addition to these heightened diligence standards we talked about in the pre-contract phase, you do have these other requirements in your contracts. So some that I find are pretty onerous and that vendors have a hard time with, becoming okay with are, let's see, for the SLAs and subcontracting terms, just add a little bit more detail. Not anything that is really crazy there, but for example, in the SLAs, you would have to include specific qualitative and quantitative measures, and you have to have reporting mechanisms baked in. So, whereas for the general contracts, you would be able to say service provider will comply with these uptime commitments. This actually has to say, we will do this, we'll respond in this amount of time. This is your remedy if we don't do that. Here's how you can check on us and make sure that we're actually meeting these requirements. So that's the kind of difference in the level of detail for those requirements. In terms of the actual just completely new concepts and obligations here, one of them is auditing. So you have to provide the financial institution with extensive audit rights in that case. So the actual language in the regulation is unrestricted rights of access, inspection, and audit. The obligation to fully cooperate during on-site inspections, and this has to be at a predetermined frequency and scope. So you're agreeing to a certain number of audits, a certain scope of the audit years in advance, and then the bank actually has the obligation to follow through and actually do those audits. So that is a lot more, I mean, again, like the word unrestricted, that is a lot more aggressive than what I would be comfortable agreeing to as counsel for the service provider in that case. But that is what's required under the regulation. Other things, you have to participate in certain pen testing efforts with that institution. You have to have a mandatory adequate transition period for any termination. So if you're providing a service that supports critical or important functions, you have to commit to providing services for a certain amount of time after termination in order to limit the amount of disruption to the financial entity. And that might mean that even if that financial entity is a terrible customer, they don't pay on time, they're violating your, acceptable use policies, things like that, you still can't pull the plug and just end it there. It has to be stable enough for that institution. And then you have to also notify them of any development that might have a material impact on your ability to effectively provide the services. Again, really broad, but that is what's required of this heightened tier of service provider.
Great. So I think, we've been harping on this, we'll probably continue to harp on it, but that critical or important function really is a potential game changer in how you're entering into these processes. With these kind of requirements, diligence processes, contract, terms. What do we see as the impacts, either both on current agreements that are already in place and may have been in place for years and years, as well as, if you're entering into new contracting processes, or maybe new financial institutions, or getting your product into the EU for the first time?
Yeah, so I mean, if you already have customers that are in this space, you may have already started getting questionnaires, requests for contract terms that address these things. But in general, this will require the financial institution to reopen contracts with their vendors. And typically the way that they do it is by starting with the more important ones and then kind of working their way down. Because I mean, these like banks, they have so many of these third-party service providers, they can't renegotiate everything all at once. So it might not have trickled down to your particular company for that customer, but they do have to kind of incorporate these into existing contracts. So you'll see reopening of these agreements that are already in place. And then when they are asking to include these additional terms or revise the agreement as a whole to include the mandatory contract clauses, there are a few different ways that this has worked. So sometimes the customer will just hand you their form and say, this is what we are required to give you by regulation, sign it. And then usually it'll go way beyond what is actually required. So you have to kind of have a sense of what is, I mean, maybe uncomfortable, but necessary, and what is just kind of pushing the bill a lot further than what you actually need. So that's kind of when the customer sends you their own form. Sometimes they'll ask for the vendor's form. So it's not unreasonable for them to say, hey, you probably have other customers that are regulated by DORA or some other, similar regime. Send us your document that addresses all this. And then that kind of puts the pressure on the vendor to create those terms, provide an addendum of sorts. This can be, preferable to using the customer's form because, in all contract situations, it's easier to start with your own form. You're putting the other side on their back foot then. So if it is possible to have these kind of ready to go, that is a helpful thing for vendors to have, just to be able to say, hey, we've already considered all this, here you go. And then it's the narrowest version of those obligations. And then there's the option of providing kind of like a mapping document here. And this is something that we've seen from vendors like Oracle and Google. If you just go and look up their DORA compliance materials, they basically have published these matrices and tables that say, these are all the obligations, or these are all the required terms under DORA. These are the specific locations in our contracts where we have already addressed these. So feel free to check it off your list. Like, we've already met all of these requirements. We don't have to renegotiate anything. That works really well if everyone is on the same paper and all of your customers have the same contract essentially, but not really if this is something that is going to vary a lot contract to contract. Then you have to kind of do a mapping exercise for every single one of them. So the best approach here is really going to vary based on your own circumstances and what your customer agreements look like. But those are the ways that contracts are being negotiated and reopened here. And then, like we were talking about, that pre-contract risk assessment phase for the financial entity, it's just a longer diligence process. Like, even if you're not classified as a vendor that is supporting critical or important functions, they still need to complete that diligence. They need to make the assessment, record the assessment, make sure that all of their records are satisfactory to regulators, because they are going to have to provide those annually. And then, longer term, if you're subject to those audit requirements, it's going to mean more oversight from your customers. So just, you're going to be subject to audits and evaluations. If you're required to participate in specific training exercises, all of that is going to be a little bit more burdensome. I know that, I mean, for privacy related issues, customers might say, hey, we actually have to have a right to audit you under GDPR. They might not exercise that. It's really, it's expensive to audit a third party. So that's not something that companies do unless they really have a reason to do that. But under DORA, they are actually required to stick to that schedule of auditing. So you'll see a lot more actual involvement from your customers and what's kind of going on internally. And then you kind of have to offer more termination rights. You have to be more flexible there. I know that software providers do not want to agree to a right to terminate for convenience. That is kind of what you're going to have to be comfortable with for these contracts. And there are ways to mitigate the impacts of that. You can always say, like, you can terminate without cause or terminate because there's some remote possibility of something affecting our ability to provide services, but you can't get a refund for it. There are ways to do that and kind of apportion those costs. And then if you are kind of classified in that higher tier and you have to agree to these more prescriptive contract requirements, like I was discussing before with the SLAs, if you have to provide that reporting, you might not have a way for customers to just view your historic uptime. Like sometimes, I mean, sometimes providers will have just a URL that shows the status of the page, what it's looked like in previous months, give you response times, things like that. Sometimes providers don't have that kind of reporting and they rely on the customer to notify them if the platform is unavailable. That is not going to be the, that's not an option if you are held to these higher standards under DORA. You actually have to provide this reporting proactively and give the customer a way to easily monitor you. And you have to provide remedies if you don't meet those requirements. So that might mean, you know, internally finding a solution for this or engaging another third party to help with that reporting function. So all of that is going to add a little bit more expense onto your plate.
Yeah. You know, it's interesting with, you know, I think we've gotten some great context here. I think kind of dove into the background of the regulation, but at the end of the day, being a provider that is US based seems that we may be at a slight disadvantage going into this as the regulations getting rolled out. You know, EU vendors may have been following these or at least kind of like had them in the back of their minds or were aware of them from more kind of institutional knowledge. You know, would you say, or what would you say are kind of the order of operations for next steps that some of the companies on this call or in general that operate in the space may be able to take to set themselves apart as a US-based vendor moving forward?
Yeah. Yeah, and I think that's exactly right. So if you kind of think back to that slide I had earlier with the map kind of showing the different operational resilience regimes, it has been pretty piecemeal, and actually the EU wasn't even on that map. So this is all just other things that have been in place. So if you have financial institution customers that are operating in France, they have had regulations already, and they have legal requirements that you may already have in your contracts because of that. But for most US vendors, these things are going to be new. So the bottom line is that the financial entity wants to ensure that their vendor is going to enable them to meet their obligations. They have a lot of obligations under DORA, and anything that the vendor can do to make it quicker and faster and like simplify that process is going to go a long way in, I think, just improving your relationship with that institution, kind of setting yourself apart there. But of course, there are some, you know, actionable steps that I think everyone should at least consider, this might not be appropriate for everyone that's on this call. It's really going to depend on your specific situation. But I think, like with most new compliance obligations and regulations, you're going to start with scoping. So just consider whether your customers are likely to be subject to this. And then self-classify. So we have talked so much about that critical or important function distinction and everything, and there are criteria that can be used to assess whether a vendor meets that standard. Do that exercise yourself. Do it, put it in writing, come up with an actual conclusion there. Because if you are saying to a financial institution, hey, this contract has these terms that we're actually not obligated to agree to because we don't meet this threshold, it's going to be a lot easier to hand them something in writing saying, this is actually the analysis that we did, and they can go ahead and file that away, and that satisfies their own diligence obligations. So that is going to set yourself up really well for your position in those negotiations. And I mean, if you're really on the fence, like there's a strong argument that you do support a critical or important function, it might not be worth it to push back. But you should know and kind of have that idea in mind so that you're you're actually expecting what needs to be included, you know what the banks are going to be asking you for, et cetera. So do that assessment yourself. Then do a gap assessment, see what is in your contracts. If these are things that you are going to be subject to by virtue of providing services to these entities, you'll want to take a look at your existing practices, relating to reporting, testing, see what's in your contracts. Like if you don't include an SLA in your contracts now, you may want to consider just having that added on as an exhibit so that you're prepared for this. If there are things that you need to actually implement in your back-end processes to meet these obligations and satisfy bank or financial entity requests, I would recommend doing a pricing exercise and just kind of seeing what that's going to cost you, seeing if it makes sense to bundle that into your actual pricing for these institutions. That might be a way to offset the costs yourself a bit. And then, I mean, like we said, updating contracts, that's something that you can do proactively or, wait until you're prompted from a financial institution. Like I said, they have fewer than 2 months to get this done. So if they contact you on, January 10th and say, we have to have this executed a week from now, sign it. It puts you in a really tricky position. So if you know that that kind of thing might be coming your way, then have forms in place, have a game plan, even offer it up ahead of time, and that would certainly be appreciated by your customers. I don't think there's any harm in kind of taking that more proactive approach, but that does require some investment of time and resources to do that. I would suggest also preparing for what customers are going to be asking you for. So like we said in our prior slides, there are things that, they're going to want from you in terms of auditing, pen testing. Anticipate what the asks are going to be and what your responses are going to be to that. So be aware of what you actually have to agree to, because it's not going to be worth it to argue with them about that when it's a regulatory requirement. You're going to want to just know what you have to say yes to and then what you can kind of negotiate a little bit. And then if you're really looking to ease the procurement process and set yourself apart that way, a great way to do this is to make sure that you have obtained all of the third-party reports that customers are going to ask you for. So that's SOC 2, the ISO, your proof of PCI compliance, if that is applicable to you. Have those measures done, because having a third-party validation of your practices makes it a lot easier for banks to do that diligence. So being prepared with that and being able to offer it up to help them, check off the boxes on that exercise will help a lot. And being prepared with responses and things that can be provided to the bank in writing for their records is going to move you up the queue in the procurement process. So there are a lot of vendors that are, kind of in their contract management system that are still being evaluated, and all that diligence is happening before the contract negotiation process even starts. It'll be definitely to your benefit if you can reduce the amount of work that needs to be done by the bank, and then kind of make sure that they get to you sooner rather than later. So there are definitely a lot of steps that you can be taking. I would consider what makes sense for your organization financially. Really think about who your customers are, who you're targeting. If you're trying to access a new market that might be subject to this regulation, these are things that are already kind of going to be a ding against you if you are not based in the EU or in a country that has had these requirements for a long time and they know what to expect from their vendors. I think for companies that are operating in the US, there's already there's a level of apprehension because we're not directly subject to as many of these laws. So being able to show that you're in the know, that you have all of this together, I think will really go a long way.
Awesome. Yeah, absolutely. I mean, it really sounds like the key is knowing who you are, what your business is, how you fit into this landscape, and kind of be proactive and make it easier on customers or potential customers to show that, hey, we're ready to roll, and can kind of make this process easier for you as we go through it. I think we have time for a couple of questions here. We're going to pick questions that are broadly applicable for the folks on today's call. If you have some specific questions that we unfortunately aren't able to address, we're of course happy to discuss offline after this webinar. So I think the first one is, we've heard this a couple different ways, Charu, but I think when we talked about the potential for more onerous audit rights that are potentially annual, monthly, weekly, depending on what you agree to ultimately, the thing you go with that is cost. Who's responsible? Do the regulations require financial institutions to pass on those costs to vendors, or is that a negotiable area, as with many of the other pieces we were talking about?
Yeah, so that is a great question, and that comes up pretty regularly when we're talking about vendors that are kind of on the smaller side of things. So there's no requirement for the vendor to take on those costs. You can always negotiate that. And the regulations don't have their own cost shifting framework. This is basically something that's going to be up to the parties. So it is perfectly reasonable to say that costs will be borne by the financial entity. Something I've been seeing a lot recently is the financial entity is saying something like, we will be responsible for costs up to X amount per audit. I don't love that because they're still the ones that are determining the scope and frequency of the audits. So something to just kind of keep in mind, but you are absolutely, able to kind of negotiate how all of those costs are apportioned. And like I was saying earlier, it might make sense to bake that into pricing for financial entities if you have a lot of those customers and are expecting this to kind of be a recurring theme.
Great. Another question, what is required of vendors, of ICT vendors, and are there flow down requirements that then will need to get pushed down from there contractually?
That's a great question. So these requirements, basically go all the way down the subcontracting chain. So like in any sort of contractual arrangement, you're only required to flow down terms that apply to your subcontractors and say that they need to be flowed down. So if the agreement with the customer says that you and all of your subcontractors will do X, then that needs to be flowed down to your subcontractors as well. But the bank's obligations are, with respect to their contractors, subcontractors, like everybody down that chain needs to kind of be part of this process. So that is also why you'll see some requirements under DORA where, the agreement has to require the vendor to notify the financial entity if they're planning on processing in a new location. That's like, it's a pretty onerous requirement, especially if you have a lot of sub-processors that have data centers located in different places. But yes, I mean, it does have to kind of be pushed down if that is something that your contract says, and it's likely going to say that because that's what the financial entities have to pass down.
Well, thank you so much, Char. This has been a lot of fun for me, and I hope it was a valuable overview for those that have tuned in, and how vendors can really navigate the potential challenges or kind of new landscape that we're seeing from DORA, and maybe some flow down impacts of that, both if you're having customers in the EU, as well as maybe what we're going to see come in the US if a similar regulation comes to bear. So I think with that, thank you all for joining us. We really appreciate it. Like we said, this recording will be circulated afterwards, and we hope everyone has a great rest of their day.
Great, thanks everyone.